Okay, so few people in the world have more say about the legal relationship between the United States and the 574 native nations recognized by the federal government than Brett Kavanaugh. That should seem a bit weird. I doubt that even Justice Kavanaugh would describe himself as an expert in Indian law. He is powerful not because of his knowledge or insight, but because he is one of 9 Supreme Court justices. And the Supreme Court is powerful. A little bit more specifically, he is powerful because he is part of a conservative majority that tends to vote for states and against tribes and the federal government in Indian law cases. He's the author, Justice Kavanaugh is, of some of the most significant Indian law opinions in recent years, 2 of which he wrote for 5-4 majorities. But it's a lone concurrence that I want to talk about today. This concurrence concerns the 14th Amendment, which is why that I'm talking about it, although sort of. I mean, if we want to be super specific, it involves the reverse incorporation of the 14th Amendment's Equal Protection Clause against the federal government through the Due Process Clause of the Fifth Amendment, but details. So, concurring in Holland v. Brackeen, Justice Kavanaugh took the position that the Indian Child Welfare Act, or ICWA, has serious equal protection problems. This position will be articulated again, as ICWA's opponents attack its constitutionality again, as they will. I think it's quite wrong, but I want to talk a little bit about why it seems plausible to Justice Kavanaugh before I criticize it. So, 2 years ago, in Brackeen, the court upheld ICWA against a three-pronged constitutional challenge. Justice Barrett's opinion for the majority, 7-2 majority, rejected 2 arguments against ICWA's constitutionality while reserving another. The first 2 arguments charged that Congress had exceeded its delegated powers over Indian affairs in enacting ICWA. The third argument was an equal protection argument. And Justice Kavanaugh concurred to basically say that he agreed with it, even though the plaintiffs in Brackeen didn't have the standing to raise it. He wrote that under the Act, under ICWA, a child in foster care or adoption proceedings may in some cases be denied a particular placement because of the child's race, even if the placement is otherwise determined to be in the child's best interest. So Justice Kavanaugh apparently believes that Indian is a racial classification and should be strictly scrutinized. Now, none of the other justices who wrote in Brackeen addressed this argument directly. I think that Justice Kavanaugh found his way to it by relying upon structural constitutional reasoning concerning the relationship between the federal government, the states, and native nations that he's deployed elsewhere. And I'm thinking in particular his majority opinion in Oklahoma v. Castro Huerta. Castro Huerta arose from tragedy. In 2015, Victor Manuel Castro Huerta, a non-Indian, was convicted in Oklahoma's courts of criminal neglect of his stepdaughter, a Cherokee citizen, on the Cherokee reservation. The state appellate court ruled that because the crime took place within the reservation's boundaries, Oklahoma lacked jurisdiction over it. Oklahoma contended the criminal jurisdiction over all crimes committed by non-Indians within state territorial borders is presumptively concurrent, shared between state governments and the federal governments in Indian country, even on reservations. A 5-4 court with Justice Kavanaugh writing for the majority agreed with Oklahoma. For Kavanaugh, this is a federalism case. 10th Amendment says all powers not delegated to the federal government are reserved to the states. There's a presumption that states can do what they want unless the federal constitution tells them that they can't. Kavanaugh looks at federal law governing Indian affairs. He sees states claiming authority over native nations and peoples within their territorial borders, and he thinks, presumptively, states should win. They should win those conflicts. Unless Congress clearly, expressly removes state criminal jurisdiction over reservations, states have it. He writes that as a matter of state sovereignty, a state has jurisdiction over all its territory, including Indian country. Now, Justice Gorsuch's dissent, may be the most excruciatingly thorough demolition of an opinion of the court in recent history. He chooses the words in his Castro Huerta dissent carefully, and his label for Justice Kavanaugh's mistake is particularly well chosen. Foundation. It's It's a mistake concerning constitutional structure. There are 574 self-governing tribal nations missing from Kavanaugh's account of constitutional structure. His structure includes states and the federal government as sovereign entities, but not Indian tribes. He never calls tribes sovereign. He sees only two types of sovereigns, states and the federal government. States can generally do what they want. Tribes are parts of states. So what does this have to do with ICWA and equal protection? Equal Protection Clause protects individual rights. Doesn't seem to say anything about constitutional structure. But zoom out a bit and read Mark's book, and you'll find quite a bit about constitutional structure in the 14th Amendment. In fact, most of the 14th Amendment is concerned with structure as a means of securing individual rights. And although Reconstruction Republicans were not, in general, particularly solicitous of indigenous claims, on which more shortly, the 14th Amendment reaffirms tribal sovereignty as a component of constitutional structure. And the key to seeing that is the Citizenship Clause. The Citizenship Clause of the 14th Amendment is structured around an understanding that citizens of native nations were not subject to the jurisdiction of the United States and not converted into citizens of the United States by the 14th Amendment. They were citizens of other sovereign nations with which the United States had treaties, and in many cases was at war. The Reconstruction framers didn't want to force citizenship upon them. They didn't think that they could. They also didn't want to deny U.S. citizenship to people who renounced their citizenship in tribes. In 1870, the Senate Judiciary Committee asserted that an act of Congress which should assume to treat the members of a tribe as subject to the municipal jurisdiction of the United States would be unconstitutional and void. But the 14th Amendment proved a parchment barrier where tribal sovereignty was concerned thanks to developments that were set in motion long before its ratification. Abraham Lincoln delivered the Emancipation Proclamation right at the end of the 6-month U.S.-Dakota War, which ended with the elimination of the Dakota Reservation, the cession of millions of acres of land, executions, and forced expulsion. Focused on the Confederacy, Lincoln largely deferred to Union commanders in the West, who participated in absolutely brutal campaigns against Native people to the benefit of white settlers. Native nations signed treaties under threat of continued military action, and the asymmetric terms of those treaties went unenforced against settlers. An expanded military capacity was turned towards what congressmen, intellectuals, and social reformers, including reformers within the Republican Party, became convinced was an Indian problem. And the solution was the development of institutions that were designed to eliminate Native cultures. Congress divided communally owned tribal property into individual parcels of 160 acres for heads of households and put the surplus up for land sale and development. The Supreme Court held that this was fine. Congress was said to have plenary power over tribes that included the power to enact laws that operated directly on Native nations without treaty-based agreements. The following year, Congress banned the executive from making treaties with tribes. The Supreme Court held that was fine, too. The Bureau of Indian Affairs removed Native children from tribal elders and their families to boarding schools, hundreds of miles away, where they were kept for years and taught to be ashamed of their families, their cultures, and their tribes. Again, according to the Supreme Court, constitutionally fine. ICWA was a response to conditions that were downstream of moral and constitutional atrocity. At the time that ICWA was enacted, state agencies placed 85 to 90% of Indian children removed from their homes in non-Indian homes. Congress found that state agencies discriminated against American Indians who wished to be licensed by the state as foster parents. Indeed, state agencies still routinely misunderstand Indian cultural practices. Separations were frequently carried out without due process of law, Congress found. Children and their parents rarely had counsel. In enacting ICWA, Congress recognized the mass removal of Indian children by states threatened the continued existence and integrity of Indian tribes at a time when tribal sovereignty was already at a low ebb, in part because of Congress's own policies in the preceding decades, facilitated by the Supreme Court's endorsement of plenary power. Indian in ICWA is an affirmation of tribal sovereignty, an effort to repair damage inflicted by and through the denial of tribal sovereignty. Kavanaugh's characterization of the equal protection challenge to ICWA as serious follows directly from his failure to appreciate tribal sovereignty as a component of constitutional structure, of the Constitution of 1787, of the Constitution of 1868. If you don't think that native nations are really sovereign entities under the Constitution, you don't have the conceptual scheme that you need to see what kind of classification Indian is, constitutionally speaking, and why defining Indian child as Congress has in ICWA isn't the sort of thing against which the Equal Protection Clause is directed. Now, Anglo-Americans in the late 18th century understood the term Indian to carry both racial and jurisdictional meanings, sometimes at the same time. So the Constitution of 1787 refers to commerce with the Indian tribes. It appears in a regulatory and diplomatic context in a way that clearly expresses a jurisdictional understanding. Tribes are treated as governing entities. Commerce with foreign nations, with the Indian tribes, among the states. So they're sovereign, but also they're different than foreign nations. What makes them different? Well, Indian nations are regarded as tributary and feudatory states. They're sovereign, but they're under U.S. protection, and many early treaties with tribes effectively cut off the ability of tribes to make treaties with other nations. They're locked into exclusive trade relationships. Okay, why? Why are they different? It's hard to provide an answer to that. They can't be cashed out in some degree in terms of racialized perceptions of native inferiority. But the term Indian in the Constitution and in ICWA is jurisdictional, not racial. The Constitution and ICWA don't tie Indianness to blood, but to sovereignty. And a key precedent that Kavanaugh doesn't even cite, Morton v. Moncari. The court upholds the constitutionality of an employment preference for Indians in the Bureau of Indian Affairs. The court reasons this isn't a racial classification because the statutory definition of Indians includes only members, citizens, of federally recognized tribes. Now, ICWA's definition of Indian child isn't identical to the one in Moncari. Even if you're not a member of a tribe, your eligibility for tribal membership and biological descent from a tribal member qualifies you as an Indian child under ICWA, but the distinction between Indian and non-Indian still doesn't turn on race, but upon connection to tribal citizenship. In fact, if we're comparing them, whereas the preference upheld in Morton v. Moncari required 1/4 or more degree Indian blood, ICWA requires no such thing. It's all about eligibility for tribal citizenship or descent from tribal citizens. Now, one leading argument that Indian is a racial classification turns on ICWA's extension of placement preferences to Indian families who are not members of a child's tribe. So the argument is that by treating all tribes as fungible, Congress is effectively saying there's a generic thing called Indianness, and that's racial. This can't be right. That would mean that every time Congress enacts a statute that isn't tribe-specific, it's relying upon notions of generic Indianness that are racial that trigger strict scrutiny. That doesn't just mean that an entire chapter of the U.S. Code, literally entitled Indians, is presumptively unconstitutional. It means that the Constitution itself engages in presumptively unconstitutional racial discrimination by empowering Congress to legislate with respect to commerce among the Indian tribes. The much better view, I'd like to suggest, is that Indian may or may not be a racial classification. That may be more complicated than some would like it, but it's unavoidably so, because the Constitution and its government structures and the persistence of sovereign nations acknowledged by those government structures make it so that Indian might be a political term, might be a racial term, might be both. Again, Indian in the Constitution is complex. Moncari's political, not racial, is a little bit too easy. A little bit too easy. But even granting that some uses of Indian would constitute racial classification, ICWA's Indian child definition is not one of those uses. Most tribes do determine membership by reference to blood quantum, but there's no serious argument that Congress, in enacting ICWA, intended to support specifically racial membership criteria. What Congress intended to do, which is what we care about under Equal Protection Doctrine, is to support tribal self-determination, however tribes sought or seek to self-determine. The Constitution doesn't dictate how other sovereign nations set their citizenship criteria. It does empower the federal government to support the persistence of sovereign tribal nations, and that's what it did with ICWA. ICWA is the fruit of a remarkable native-driven effort to convert plenary power from a sword against tribal sovereignty into a shield protecting it. It was designed to protect native nations against states that were practicing the same kind of cultural destruction that the federal government modeled through its boarding schools by targeting native children. It distinguishes between Indians and non-Indians in order to prevent ongoing cultural destruction. To treat that distinction, drawn for that reason as a form of presumptively unconstitutional racial discrimination, is to effectively pronounce the end of tribal sovereignty as the constitutional matter. And this is ultimately what opponents of ICWA want. Their arguments have a genealogy and substantive content that makes that clear. These arguments were raised following congressional commitments to tribal self-determination that was the fruit of Native advocacy and institution building. That's why it's called the self-determination era of congressional policy, which we're still in, despite Supreme Court decisions cutting back on tribal sovereignty. These arguments rest on the premise of a colonizing constitution that makes every native child in the territorial United States a U.S. citizen on whose behalf the United States can intervene. It treats tribal interests as just interests. It can be morally and legally overridden by the imperative securing the individual rights of people who are first and foremost individuals, not members of political communities, that ICWA's opponents fundamentally do not trust. I don't doubt that they believe what they're saying, but what they're saying is continuous with the paternalistic spirit which inspired the very conditions that ICWA was designed to alleviate. I want to conclude with something that perhaps goes without saying at this point, but I'll say it anyway. Congress and the executive and the states with the courts' constitutional support discriminated against Indians generically as Indians. For the court to say at this juncture, now the federal government can't take measures to remedy or counteract that discrimination without micro-targeting particular tribes wouldn't just be constitutionally off base, it would reflect a sickening lack of appreciation of its own institutional responsibility for the conditions that necessitated ICWA. In violation of the Constitution, the federal government and the states discriminated against Indians with little to no constitutional scrutiny. But now that the federal government is trying to remedy and prevent discrimination going forward, strict scrutiny. Come on. I don't think Justice Kavanaugh is a fool, and I don't think that he intends harm. I do think that he, like many justices of a variety of political persuasions, thinks that Native nations don't quite fit into his understanding of the Constitution's structure and is trying to force them in anyway. He's right that they don't fit, and I wish I could say that's just a problem with his understanding. But few people in the world have more say about the legal relationship between the United States and 574 Native nations than Brett Kavanaugh, and so it's everybody's problem. I want to end on an optimistic note. Precisely because there's nothing remarkable about Justice Kavanaugh. He's only as powerful as the institution of which he's a part. And that institution hasn't ever been as powerful as it thinks it is. Native nations have not only survived, they've thrived in spite of only sporadic support from what Chief Justice Marshall once described as courts of the conqueror. They will survive and thrive in spite of Brett Kavanaugh.
Okay, Professor Ferguson.
So in my remarks today, I want to suggest to you that Section 1 of the 14th Amendment contains a social mobility principle. The principle that under the 14th Amendment, the law ought to promote an equality of socioeconomic opportunities. As a historical matter, I think this is important because we need to know Section 1's fundamental purposes, but it's also an important matter today. Section 1's social mobility principle suggests that Congress has more authority to address disparities in socioeconomic opportunity than we might ordinarily think. And it suggests that courts can do more than standing doctrine suggests to protect individuals against invidious forms of discrimination. So the social mobility principle is different from other fundamental values typically associated with Section 1, like anti-subordination or anti-classification. The anti-subordination principle posits that Section 1 prevents the government from further subordinating disadvantaged groups. Here, though, the social mobility principle, I think, is further reaching. It holds out its requirements for all individuals, not simply those recognized in the suspect class's framework. It's also further reaching, I think, than the anti-classification principle, which posits that Section 1 requires treating all individuals alike. Under the social mobility principle, government must affirmatively ensure that all individuals have sufficient opportunities to compete on equal footing in the marketplace. So because it's different, I think, than other Section 1 values, the social mobility principle will have some different implications for how we think about Congress and the courts in terms of their constitutional rights and duties. And I'll discuss this briefly at the end of the talk, but first I want to turn to history and text of Section 1 to indicate why I think that this principle is central to its purposes. So ultimately, the social mobility principle may be traced to the Reconstruction Republicans' shared anti-caste and free labor commitments. While anti-caste ideology opposes all forms of fixed social hierarchy, free labor ideology holds that every person is capable of improving their socioeconomic status through labor. These views appear prominently in the constitutional theory of Section 1's primary author, John Bingham. So in 1857, Bingham argued that the Constitution prohibits slavery everywhere under federal jurisdiction because, quote, it protects not only life and liberty, but also property and the product of labor, and, quote, contemplates that no man shall be wrongfully deprived of the fruit of his toil any more than of his life, unquote. In the same speech, he would go on to proclaim that the Constitution promotes a form of government, quote, which dots the land all over with public schools and thereby gives to the people the power of knowledge, which builds and fosters those institutions which shelter the poor and houseless, and those other asylums in which the blind are taught to see, the deaf to hear, and the dumb to speak, unquote. The idea of that constitutional government should affirmatively lift individuals into a place in which they can compete on equal footing was also one that Frederick Douglass commonly promoted. Between 1859 and the mid-1890s, Douglass would deliver his famous self-made men speech over 40 times to audiences within and beyond the United States. His key message was that government must provide African Americans with the developmental opportunities it commonly secured to white workers so that they too could elevate their own circumstances through labor. For Douglass, black people had, quote, well performed the task of making bricks without straw. Now give him straw, he thus demanded. Give him all the facilities for honest and successful livelihood, and in all honorable avocations receive him as a man amongst men, unquote. As a generation of historians and legal scholars, including Rebecca Zietlow, from who I've benefited a lot, and others in this room, have shown, the 13th Amendment itself grew out of these anti-caste and free labor commitments. So here, a quote from Leah Vandervelde, by abolishing slavery and involuntary servitude, Republican radicals and moderates, quote, sought to advance both a floor of minimum rights for all working men and an unobstructed sky of opportunities for their advancement, unquote. This commitment covered even conservative factions of the Republican Party, as would be represented by President Andrew Johnson. For him, the evil of the Black Codes, passed by Southern states in the wake of emancipation, was that they denied African Americans the ability to compete on equal footing in the marketplace. So as Johnson would put it in his first annual message to Congress in 1865, quote, the career of free industry must be fairly open to them, referring to the freed people, and then their future prosperity and condition must after all rest mainly on themselves, unquote. The following year, the Republicans would use the 13th Amendment to pass the Civil Rights Act of 1866, thereby creating federally enforceable market liberties for black laborers. The act asserts that all citizens, I'll read what Professor Barnett recently read again, quote, shall have the same right to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of the laws and proceedings for the security of person and property as enjoyed by white citizens. So these were, as the historian Eric Foner puts it, essentially the rights of free labor necessary to compete in the economic marketplace. And just one more piece of evidence, as many in this room will recall, Michigan Senator Jacob Howard's speech introducing Section 1 to Congress on behalf of the Committee of 15 on May 23rd, 1866, has language that I think attests to the same idea. So he emphasized that the central purpose of Section 1, especially the equal protection and due process clauses, was to protect against caste and class legislation, such as had been typical of the Black Codes. That is, its rights were meant to prevent African Americans from being trapped within the lowest echelons of the division of labor throughout the nation. All right. So what might this imply for thinking about federal authority today? So first, I want to suggest that the social mobility principle affirms that Congress can use Sections 1 and 5 to legislate positive rights of the kind that Bingham and Douglas noted in the late 1850s. However, I think that Section 1 primarily prohibits, if we think that if Section 1 primarily prohibits group-based subordination or invidious forms of classification, I think it's not at all clear why Congress would have this kind of authority. If we think about Section 1 through the lens of social mobility, by contrast, Congress appears to have much more room to act. And this is true, I think, even under contemporary doctrine like City of Bernick or Morrison, which limited Congress to remedying judicially recognized 14th Amendment violations. The reason why I think that this expanded authority still exists is because if you think of landmark rulings from the Slaughterhouse cases to Brown v. Board of Education or Goldberg or Plyler, there's a long tradition of recognizing that infringements to social mobility or to equal opportunity are cognizable harms under Section 1. A second major implication of the social mobility principle that I'd suggest is that it affirms courts' Section 1 authority to extend anti-discrimination protections to individuals who are not members of suspect groups. So in Plyler, recall, the court held that even though non-citizen children were not a suspect class, they couldn't be excluded from public education. A key aim of the Equal Protection Clause, as Justice Brennan would argue for the majority there, was to abolish what he called caste, and which he defined as governmental barriers presenting unreasonable obstacles to advancement on the basis of individual merit, unquote. To make one more point before concluding, I want to note that I don't think that in expanding anti-discrimination protections beyond the suspect classes framework, we lose the protections of traditionally protected classes. To see why, we can think about the reason that Justice Ketanji Brown Jackson also wrote a dissent in Students for Fair Admissions. So she signed on to Justice Sonia Sotomayor's full-throated anti-subordination defense of race-based affirmative action, but she also wrote separately. Section 1 of affirmative action, its purpose is to establish a society in which all Americans, or what we might think of as all individuals, quote, can compete without race mattering in the future, unquote. Section 1 demands social mobility, or in her words, that we, quote, level the playing field and march forward together, collectively striving to achieve true equality for all Americans. Thanks.
Indeed.
Well, that's you're going to see that we're of the same mind, Lucien and I, although I'm talking about a slightly different perspective, but yeah, well, you'll hear. So, because I'm also talking about a different model of equality under the 13th and 14th Amendments than we usually think of when we think of the Equal Protection Clause. So I've become quite dissatisfied with the Equal Protection Clause, actually have been for years, and I think it's really because the court has gutted it of just about any meaning, where now it means certainly nothing, doesn't do anything for racial equality, gender equality, economic rights, nothing. So that's why I started years ago thinking about citizenship and equal citizenship under the Citizenship Clause, and also the 13th Amendment itself, which of course does provide for economic rights. So this potential for substantive equality goes well beyond the Equal Protection Clause of the 14th Amendment, and it's rooted in the activism of fugitives from slavery, free black people, and their anti-slavery allies in the antebellum era. In the antebellum era, they articulated a free labor vision that included not only abolishing slavery, but establishing a vision of economic empowerment that Lucien was just discussing that would promote economic equality of working people. And a vision of citizenship rights that include the fundamental human rights of equal citizenship. And the Reconstruction Congress constitutionalized that vision with the 13th Amendment, which protects fundamental human rights, protects against undue coercion and involuntary servitude, and against the badges and incidents of slavery, and the 14th Amendment protection of the privileges or immunities of citizenship and its promise of equal citizenship. The courts have never enforced these rights to substantive equality, but those rights still exist in the text, rights born of the struggles of activists that culminated in the Civil War, contributed to the Reconstruction effort, and were reflected in the ideology of the Reconstruction Congress. Central to the ideology of political anti-slavery movement and the anti-slavery constitutionalists, as some of us have talked about, that Randy has talked about today and has written about so much, who were activists, journalists, and lawyers that were involved in the political anti-slavery movement, brought some lawsuits, primarily made their arguments in political terms, and developed an anti-slavery ideology that influenced the Republican Party and was itself influenced by activists on the ground. When theorizing the meaning of Reconstruction, we should follow the example of these activists. The activists on the ground, and the anti-slavery constitutionalists that wrote their theories into treatises, whose own Constitution of Liberation helped to create the Constitution with its promise of substantive equality. So the 13th Amendment provides that neither slavery nor involuntary servitude shall exist, which is a positive promise of the fundamental rights that were denied to enslaved people, enforceable against state and private entities, that enforces equality in at least three distinct ways: protecting against slavery and involuntary servitude, providing a remedy for badges and incidents of slavery, and protecting the rights of citizenship. The abolition of involuntary servitude, and not just slavery, in the 13th Amendment reflects the free labor vision of many anti-slavery activists, some of whom were also engaged in the antebellum labor movement, who opposed slavery not only for humanitarian reasons, but also because the existence of slavery hurt all workers by lowering not only wages, but also conditions of work. They understood that people held in involuntary servitude, including peonage and apprenticeships, lacked the power to negotiate for better wages and conditions. Equality in the workplace requires not only freedom from race discrimination, but also from freedom from undue coercion by employers. And so I've argued that the 13th Amendment protects positive rights for workers, what I call a positive right to free labor, freedom from undue coercion, from race discrimination, and arguably discrimination based on other immutable characteristics, and the right to a fair wage. And you'd have to read my work to go into more detail, where I talk about how this was enforced by the Reconstruction Congress and also Reconstruction governments in states under the rule of Reconstruction after the war. But in particular, enforcing the 13th Amendment, Congress enacted the 1866 Civil Rights Act, which justly has gotten a lot of attention today. Randy read some of the language that I was going to read as well. And the 1867 Anti-Peonage Act, which protects against in the holding laborers in involuntary servitude, which Congress has amended a number of times to expand. And most of the cases, the cases where courts are enforcing the 13th Amendment, are actually enforcing the Anti-Peonage Act. We've already talked about the fact that 13th Amendment empowers Congress and gives broad powers to Congress, and as well as addressing involuntary servitude to remedy the badges or incidents of slavery. According to William Carter, the badges or incidents are harms that are proximately traceable to the system of slavery, taking into account the group affected and the type of injury. Congress has broad power, and the court still recognizes this, still hasn't overturned Mayer versus Jones, to define and remedy the badges of incidents of slavery. And courts may also have the power to do so, at least Carter argues that. Congress has enacted laws addressing race discrimination in contracts, real estate transactions, the 1866 Civil Rights Act, the 1968 Fair Housing Act, focusing primarily on economic rights. But of course, slavery imposed such a broad deprivation of human rights on every level that remedying the badges or incidents has considerably more power to promote equality. Carter argues, for example, I think very convincingly, that racial profiling and racially motivated police violence is a badge or incidence of slavery. Others, including myself, have recently argued that the denial of reproductive liberty is a badge of incident or badge or incident of slavery, especially when it applies, of course, to people who are descendants of enslaved people and other people of color. Other examples abound. Persistent racial and economic equality is so broad that, of course, poverty, health, lack of housing, I mean, all goes back to our history of slavery and Jim Crow system of economic and um, actually remedying the badges and incidents of slavery would certainly bring about more equality. Citizenship rights. As we have discussed, the very first act of Congress enforcing the 13th Amendment, the 66 Civil Rights Act, statutorily established birthright citizenship. Now, in Dred Scott, the court had held that people of African descent could not be citizens, and the Citizenship Clause of the 1866 Act directly repudiates that ruling, which means even that members of the Reconstruction Congress believed that enslaved people became citizens as a result of the abolition of slavery, or that they simply thought they had the power to overturn the Supreme Court's Dred Scott decision on their own, and I've written about that as well. Very, very broad protection of rights, as we have talked about, and was constitutionalized with the 14th Amendment. Finally, I'm getting to the 14th Amendment. Privileges or Immunities Clause. The concept of citizenship was central to how people thought about rights in the antebellum era. Fugitive slaves risked their lives to escape to freedom. They asserted their right to travel, sought protection when they reached free states, and they raised crucially important questions about citizenship. Could they be citizens of either a state or federal government? Were they entitled to protection of the government of free states? Or were the free states bound by the Constitution to assist slave catchers in returning them to captivity? Freedom to travel was also important to free black people who risked being kidnapped and enslaved not only when traveling in slave states, but also while at home by slave catchers purporting to recover fugitives from slavery. Some northern states enacted laws prohibiting free black people from entering and denying other rights, such as the right to appear in court and serve on a jury to free black people, while other northern states argued that free black people from their states were citizens entitled to move across state borders without fear of being kidnapped and sold into slavery. Someone talked about this, the whore, and I think it was maybe yeah, it was Earl earlier today. It was related to racial equality because the whole point was Hoare was traveling and trying to make the point that black citizens from Massachusetts should be able to travel into South Carolina without being arrested and sold into slavery. The colonization movement, in which people argued that free black people should return to Africa, also raised fundamental questions about belonging and exclusion. And in what Kate Mazer has called the first civil rights movement in the antebellum era, free black activists argued that they were citizens of their states entitled to fundamental human rights, and they argued that they could be U.S. citizens as well, applied for passports, etc., to make this point. They championed the concept of equal citizenship essential to belonging. And their anti-slavery constitutionalist allies argued that citizenship right came from sources including the structure of the government, the Article 4 Privileges and Immunities Clause, and natural rights, fundamental human rights. They focused primarily on the rights of free blacks, but also argued that people who were formerly enslaved would be entitled to the rights of U.S. citizens, and of course, in both the 1866 Civil Rights Act and the Citizenship Clause of the 14th Amendment, the Reconstruction Congress and our country, which ratified the amendment, made this the law of the land. Citizenship rights include, I have argued, belonging, the rights to belonging, protection, and equality, belonging and being a full member of your community, the right to protection from your community, the right to protection of your rights, and against the infringement on your rights, including, of course, being kidnapped when you were traveling, but other rights as well. And equality, some argued that rights of citizenship were broader, encompassing all fundamental human rights. Kind of nice to give my talk at the end of the day, because Jacob Howard's speech that someone, maybe I think it was Randy, is an example of that. Corfield versus Coriel that Randy has already laid out, so I don't even need to talk about it. And they opposed Northern Black codes, and of course, then they supported the right to uh, freedom from race discrimination in the 1866 Civil Rights Act and other measures, including in the Reconstruction Act and the Freedmen's Bureaus Act that the Reconstruction Congress enacted. Um, so so both the freedom from involuntary servitude, the rights in the 13th Amendment, and the right to citizenship and equal citizenship create a substantive promise of equality with a focus on positive rights, the right to belong equally as a member of the polity. This is a potential that I don't expect ever to be enforced by courts, but only by the political process and the political branches, which has always been the case throughout our history, from the anti-slavery movement all the way through to today, labor movements, civil rights movements, other rights movements, boots on the ground. But as I've discussed in a number of places, engaging in constitutional argument can be very effective as a political argument as well. And so this substantive equality vision can be enforced in that way. Thank you.
Anything the panelists want to say to each other?
I have something I want to say.
Oh, sure.
I went to law school with Brett Kavanaugh. He was in my class, and I took federal courts from Judith Resnick. And and she talked about she incorporated the jurisdiction of tribes into federal courts, and it fundamentally affected the way that I think about federalism. And it's a shame he wasn't in that class, or if he was, that he didn't pay attention.
So I guess first question for Evan. When you hear, so I'm imagining, you know, take a copy of Morton versus Martin Curry, get in your time machine, go to 1866. I think the first thing they're going to, I mean, I guess they're going to, the Reconstruction Republicans are going to say two things about this. One is, why is the right to be an officer of the government a civil right at all? So they would look at this distinction between a political classification and a racial classification. They would say, well, that's not what we should be. We should be talking about political rights or political equality versus civil equality. And of course, secondly, they would say, but civil equality has to do equality among citizens. These folks aren't even citizens. And then you'd have to, of course, explain the 1924 imposition of citizenship. But so Morton, one way to disagree with Morton is to say, 14th Amendment equality shouldn't even apply to governmental offices. But another way would be to say, maybe the Indian Citizenship Act is unconstitutional. But if the Citizenship Act is constitutional, and we look to a context where we are talking about civil rights, it's hard. It's hard to say that a genealogically based classification isn't arguably racial in the way that strict scrutiny says racial classifications are bad. Maybe this pushes back against strict scrutiny for all racial classifications. But anyway, react to some of those distinctions, please.
First of all, I want to turn the microphone on. Okay, so first of all, I want to be clear that in my remarks, I was taking for granted the conventional view that the Equal Protection Clause encodes a generalized anti-discrimination principle and is not a more narrow, positive duty on the part of the state to protect you against violence, which I actually think the latter is the more accurate understanding of the original meaning of the Equal Protection Clause. Okay, so let's talk about blood quantum and its relationship to race. I think that there is a plausible to probable argument that if Congress had codified a statute which required the federal governments to take account of blood quantum for the purposes of the distribution of any benefits or in any capacity, you could argue that that was a racial classification. But that's not what ICWA does. What ICWA does is to defer to tribal membership criteria that are set by tribes themselves. They don't have to, and some tribes don't, set their membership criteria on the basis of blood quantum. So, thinking about this in terms of discriminatory intent, do we think that Congress, in enacting ICWA, wanted, desired to incorporate specifically racialized criteria for tribal membership? There is no evidence whatsoever of that. Instead, they deferred to tribes. Some tribes base their membership on blood quantum, some don't. They're treated as nations that can establish their own criteria, that in their internal affairs are actually not subject, per Supreme Court precedents, to constitutional constraints more generally in doing so. There's a case in which the Supreme Court basically said that tribes as tribes are not subject to the Constitution.
Good afternoon. My name is Hayward Gordon, and I'm a 3L here at the University of Mississippi. Mr. Ferguson, in regards to your speech about the caste system, so as we know, SFA versus Harvard gave a military exception. So race can still be considered when you're thinking about the admission of students into like the Naval Academy, military academy. How does that further perpetuate the caste system, and what message does that send to minority communities or communities who, for any other reason, they say their racial class does not matter in their admissions?
Yeah, thanks for the question. That's actually so. I haven't thought about this before, but I think that the connection to caste, and not caste as it's discussed in the case, because there is quite an extensive discussion. Like if you look at and it sounds like you've looked closely at the case, like the term caste comes up maybe 40 times or so. But if you think about caste in the way that someone like Douglas or the black abolitionists talked about it as a fixed division of labor, and the worry is that your labor will not pay off in terms of an elevation of your socioeconomic status or of your dignity, and that's sort of the fundamental meaning of caste in the antebellum context. When I think about the exception for the military, there's something to worry about, which is that these are often poor kids who are, and maybe the military is a path to upward mobility today. I'm not sure. Like that's an interesting question, I think. But I also remember at my own high school, the military coming up, recruiting people from the square in the just in the middle of the school, and all these kids coming in and playing a video game and getting sort of and maybe that there's a way that is something that they need to do based on their economic circumstances, and there's this kind of compulsion. But I think the worry, just to sort of put it briefly from the caste perspective, is how does it ultimately affect their socioeconomic chances? And I think that this is maybe a different way to look at the the reasonableness of the exception. Maybe we tend to think about it in terms of, well, what are the sort of national security needs, and that kind of trumps the scrutiny sort of metric. But I think the social mobility question in caste brings something really interesting into the question as well. Thanks.
I just to add very briefly, I think there's an argument that service in the military could be deemed a political right, whereas going to Harvard, going to Harvard is, or certainly UNC, would not be. So there's an argument that training people to serve on behalf of the government, well, that's not something the 14th Amendment folks would necessarily say is a civil right. Of course, with Title VI, where it's an inequality with respect to anybody touching federal money, it's a little different. But
well, first, thank you again. As I'm listening, I was reminded Richard Flathman, who's a late philosopher at Hopkins, once suggested that we shouldn't think of liberalism as a theory, but as a family of theories that had lots of elements in common, but we shouldn't expect that all liberal theories will have this element in common or lots of elements in common. And listening particularly to Lucien and Rebeca, where I think there's a bit of homogenization that lawyers do of the 14th Amendment is it really the case, in thinking of Republicans, that they all Republicans had lots of elements in common, but there may be no one or two elements: commitment to opportunity society, commitment to Rebecca's vision, that all of them have. And to some extent, it's not a contest of extrapolating. I cover 73% of the data, you cover only 71. But at some point, we give up the enterprise and say, guess what? Lots of Republicans believe this. Lots of Republicans want to do this. It's a good thing to do. Let's do it.
Yeah, and also, it wasn't just the Congress, right? It wasn't just the Republican Congress. And one of the things I'm trying to do is to really focus on the actions on the ground, right? The movement, the anti-slavery ideology that was out there, the people, and I've been writing about fugitives from slavery most recently that were risking their lives, for freedom, and how that influenced how people thought about these things. So, but I'm not a originalist, like, Mark is not. I'm not arguing that there's one meaning. What I'm arguing is that this is one way to read these amendments that is consistent with a lot of the way a lot of people thought of them and consistent with the text.
Yeah, ditto. Well, I've learned a lot from Rebecca, and I think that I'm also trying to say that the social mobility principle is a way to understand the purposes of Section 1. And it is part of the history, part of the text of Section 1, but also part of the broader popular history and origins of Section 1 as well. And so part of what I didn't present, although it's in the paper that this is, and dissertation that this is coming out of, is that these ideas circulate broadly throughout the colored convention movement. And the reason that that's important for me is not that historically speaking, the real origins of Section 1 lie in the colored convention movement or the black abolitionists, but because they help us think about the reach and the horizons of the principles that we attach to Section 1. So someone like Frederick Douglass thinks about opportunity in a further reaching and more egalitarian way than someone like Andrew Johnson. And I think that that's helpful for us when we think about what kind of principle the social mobility principle is and what kinds of possibilities it has. So that's kind of where the popular history that Rebecca's alluding to, that's the role that it plays in the sort of broader project.
Thank you all for those interesting presentations. Just a small point for Lucien, or you can decide for yourself whether it's a small point or a large one. The you know, I would not try and you really focused on Plyler to try and link this to contemporary jurisprudence. Plyler is a complete outlier, and it's basically said this is a one-off case, whereas all of the other uh, burger court cases, beginning with Crass and Rodriguez, and the abortion and the Medicaid abortion cases, and some subsequent cases dealing. I'm trying to think. Cattermas, is that the one about the not paying for transportation of poor students to other schools? My my point being that assuming that you're going to that as you sort of build on this as it's part of a scholarly project, I think you could, I would not rely on current case law because current case law, as I said, Plyler is just Plyler. No, but uh, no, well, Justice Powell becomes the fifth vote Plyler, and he wrote Rodriguez. So that's been my suggestion that if you can say that, I can find this in the current case law, but you really need to recognize the fact that that case is an outlier from your theory's perspective. Now, if you want to argue that your theory is the right theory, guess, but that would be my.
Yeah, thanks. So I like Plyler, not only because of the outcome, but because I think that it highlights a parallel way of understanding the kind of principle that was important to the abolitionists and the Reconstruction Republicans that they linked to Section 1, and gives us a way of thinking about what that might look like in relation to the tiers of scrutiny and suspect classes doctrine as it exists. And I actually, okay, I might push back a little bit because I do think of Plyler as an outlier in general, but I also think that it is coming out of a tradition of fundamental interests doctrine, and there is um, some rich sort of similarity in the kind of stuff that Marshall's developing in Rodriguez, and so I think it is part of a broader ecosystem too. That's important.
Well, again, not uh, where it come again. Plyler is an outlier, but your argument is from the pre-Burger Court years, which seem to be pushing in that direction, and ends with Crass and Rodriguez, and after that, Plyler becomes the outlier. That's all I would suggest.
Seth. Yeah, my question is for Lucian and to the dean, if she'd like to address it too. Given that the structure of Section 1 talks about rights for citizens and rights for persons, anytime you have a normative theory of what these rights might be, unless you denude citizenship of rights, you, I think, textually have to say there's some things citizens have that other persons don't. So it's interesting what you might suggest is in that social space, that political space, that legal space, because the greater that space is, the more subject you are to people saying, well, you're pushing persons down, you're oppressing them, because you're talking about significant rights that you reserve to citizens. On the other hand, if you say that social space is really small, then you're denuding citizenship of any real influence or power or any objective for new people coming to the country to take the time to become citizens. So I really wonder how you could bridge that gap with any particular normative theory like social mobility, or to be perfectly blunt, for anything else, unless you're some sort of extremist committed textualist. So please.
Yeah, thanks for that question. I think that that historically the social mobility principle is really grounded in the natural rights theory. So I think it is part of due process and equal protection, and so part of the rights of persons. And um, and so I guess in my view, privileges and immunities clause can build on that, and that's sort of a question of what the political branches do. But applying the principle does seem to collapse the space between the rights of citizens and the rights of persons. And so,
Isn't it the real reason you find Plyler an attractive case? Because you do want to collapse that space. You think that is a good objective.
well, I think that there's rights that we reserve to citizens that should be distributed more broadly. But I think what's more important for me as I'm exploring this principle is where it goes. And then the question becomes, well, are there other things in the Constitution that then check it? Because I do think it is quite a radical principle if you want to sort of think about it expansively. And so then the question becomes, well, are there other reasons, I guess, that suggest that we should sort of reserve the space between citizenship and personhood? You brought up some of them, which I think are worth considering. But the principle itself, I think, tends to collapse them.
One way to do it would be to say 14th Amendment equality is based on citizenship. And so there's a social mobility within the citizenry that government has an obligation to promote to an extent, because to be a citizen means the government has to pay attention to your interests. For non-citizens, states aren't allowed to just have their own immigration policy. So it's a social mobility in the sense that Congress is welcoming people, so it's a kind of a social mobility, from the rest of the world here. But until you're a citizen, you don't have 14th Amendment rights other than due process, process, and then protection from violence. But you can get Graham versus Richardson on the preemption part. It's Congress is giving these rights that states can't take away, but it's going to be, again, subject to congressional will completely. under that view, and I can understand people don't like that as much. Final question in the back. Oh yeah.
This is for Lucien. This is it's kind of like a mini job talk for you. So this will be one of the friendly
Oh,
questions.
give him a fastball. Come on.
No. This is a softball, I think. I'm just curious. For your, this is sort of a question about methodology. Is it relevant / interesting, whatever word you want to use, for your project to consider the laws like the Fair Labor Standards Act, other acts regulating labor that sort of come out of the New Deal period? If it is, why? If not, why not? And you can see what I'm getting at. Like, why would you care about that or not care about it under your approach?
Yeah, thanks. I think those acts are good examples of Congress applying the social mobility principle, although they weren't 14th Amendment passed under the 14th Amendment. So I think that one of the outcomes of this approach that I'm thinking about and exploring is that acts that have universal socioeconomic benefits or subsidies, whatever you might want to call them, we get a way to see that those are ways of enforcing the 14th Amendment. And the reason that we don't see that under, say, the anti-subordination or anti-classification principle is because they're based on either groups, in the case of the anti-subordination principle, or a conception of equality of opportunity that is, in a sense, limited to the instant, you might think, competitions, or rather than thinking about the distribution of socioeconomic opportunity sort of across society writ large. So, so I do think that this gives us a way to say that the Fair Labor Standards Act is justified, that if you think about a case like Goldberg, I guess going back to the kind of importance of Brennan's line of 14th Amendment doctrine, there's a great passage in there talking about why you can't arbitrarily remove the sort of ex ante evidentiary hearings attached to these state social welfare policies, and it's because it reduces individuals to a state of slavery, puts them in a condition of sort of under an arbitrary will, where they're in a state of dependence. They can't plan their life. They can't participate fully in the marketplace. So it gives you a way of seeing why, under the 14th Amendment, something like the Fair Labor Standards Act is at least something Congress is authorized to pass. And I think a sort of second question is how this relates to congressional duties that I'm also thinking about.